Oh, and can I remind everybody to turn your phones off?
Good reminder.
Right. Okay, so we should be streaming now on YouTube. And so clerk, we're ready to go.
Okay. The Court of Appeals for the 8th District of Texas, the 8th District Court of Texas. I am so sorry, I'm so nervous. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. Okay, we have one case on this morning's docket. It is cause number 08-19-00163, civil, City of El Paso versus Joanna Congolosi, if I'm pronouncing that correctly. And that is from El Paso County. This is an oral argument that is being streamed on YouTube via the Zoom technology pursuant to the Texas Supreme Court Emergency Order number 1. For the parties' benefits, we have read your briefs, we've reviewed the record, and the court has already had an opportunity to confer amongst ourselves about the case, if that helps you in your preparation. So with that being said, Ms. Benavides, you are ready to proceed whenever, or we're ready to listen whenever you're ready to proceed.
Thank you, Your Honor. Good morning, Annalisa Benavides for the City of El Paso. May it please the court, counsel. This lawsuit was filed on February 28, 2018 against the City of El Paso pursuant to the Texas Tort Claims Act. It alleges claims of negligence, wrongful death, and survival rights of action. This court is familiar with the facts of this case, but just a short briefing of those important facts for purposes of the arguments. The lawsuit stems from an automobile accident that took place on March 4th, 2016 in the City of El Paso, Texas. Ms. Joanna Congolosi filed this lawsuit individually and as next friend of her minor daughter who suffered some injuries during the accident, as well as surviving daughter and heir to the estate of Ms. Annette Martinez, who unfortunately passed away as a result of injuries she sustained in that same accident. Ms. Congolosi's 4 brothers are also plaintiffs to the suit as surviving sons and heirs of Ms. Martinez. Importantly, Your Honors, appellees allege that the motor vehicle collision of March 4th, 2016 was proximately caused by the negligent actions of the police officers from the El Paso Police Unit. On March 4th, 2016, undercover officers for the El Paso Police Department were conducting surveillance in the area of Robinson Avenue and Stanton Street. There had been a number of burglaries in the Kern Place neighborhood a few days prior. That was the result of this undercover stint. The officers observed 2 individuals who we now know are Aaron Rocho and Jacob Sanchez. They were in a 1997 Acura backing out of a driveway of a home on Robinson Avenue. According to the appellee's allegations, Officer Villalobos, who was one of the officers who was conducting surveillance, followed the suspects in an unmarked unit. It was a 2007 Ford Focus. After Officer Villalobos allegedly began following the suspects, 5 additional unmarked police cars and 1 marked police unit eventually joined the alleged chase. This is a total of 7 police units. Appellees allege that the 7 units engaged in a high-speed chase with the intent of apprehending the suspects. Appellees allege that the suspects realized they were being followed by police and that as a result, they increased their speed to avoid being apprehended. Now, the appellees also allege that during this alleged high-speed chase, all but the marked unit chased the suspects at a high rate of speed with no emergency lights and no sirens. We all agree that Rocha was driving the 1997 Acura at a very high rate of speed. He approached the intersection of Stanton Street and Schuster Avenue, and at that point, he struck the 2009 Ford Fusion driven by Ms. Congolosi. Ms. Cangelosi had her daughter and her mother as passengers in that vehicle, and she was stopped at a red light when she was hit from behind. The force of the impact caused the vehicle driven by Ms. Cangelosi to collide into a third vehicle, a 2006 Buick Lucerne, and then Ms. Cangelosi's vehicle rotated and struck a fourth vehicle, a 2001 Nissan Sentra. None of the police vehicles, neither the marked unit nor the 6 unmarked units, ever made contact with either Ms. Cangelosi's car or with Mr. Rocha's vehicle. Now, appellees allege that the collision that occurred on March 4th at 1:30 p.m. was proximately caused by the negligent actions of officers of the El Paso Police Department. The city of El Paso disagrees with that and filed a plea to the jurisdiction. As this court is aware, the city is a governmental entity that enjoys governmental immunity from suit or from tort claims, where its governmental functions have come into play, unless their immunity is specifically waived by the act. When a suit is barred by governmental immunity under Texas court law, the trial court will lack subject matter jurisdiction, and a dismissal with prejudice becomes the proper action. In this particular case, the city has challenged the legal and the factual sufficiency of the allegations raised by appellees in their petition. Under the Texas Tort Claims Act, the city can be held liable for personal injury or death that results from the operation or use of a motor-driven vehicle. Appellees have been unable to establish a waiver of governmental immunity under this provision for 2 reasons. The first reason is that there has been no evidence of an actual chase. A critical element of appellee's case rests on their ability to show that the officers engaged in a pursuit and that the suspects knew or were aware of such a pursuit. However, all of the evidence in this case shows that the undercover officers did not engage in a high-speed chase with the intent to apprehend, but rather followed the suspects in order to have a marked car conduct a traffic stop to further investigate whether or not a burglary had taken place.
So let me stop you there, because I thought in the internal investigation or internal affairs investigation, Officer Villalobos said that he witnessed a burglary of a habitation. He defined it as a violent offense, and he knew that these 2 kids had been involved in a burglary the prior day, and said they were driving a stolen car and were on a kind of a citywide crime spree. So, I mean, wouldn't that be sufficient cause for him to actually arrest the 2 young people, as opposed to waiting for him to commit a traffic offense and continuing the investigation?
Your Honor, Officer Villalobos was not waiting for them to commit a traffic offense, but rather, if you look at the depositions of Officer Villalobos, Officer Miguel Acuña, Officer Humberto Herrera, and Officer Miguel Pacheco Jr., all of them say that as undercover cops, it was their duty, and it always is their duty, to simply follow the suspect, get on the phone, and call in to a marked unit who can then go and effectuate the traffic stop. So it's not that they're waiting for the suspects to commit a violation. You are correct. They've already identified them as suspects. But what they're doing is that they're following them just to keep track of them until the marked unit is able to arrive and then go ahead and effectuate the traffic stop. Because under policy, the unmarked unit would not be conducting the traffic stop. It would be a marked unit that would do so.
And Ms. Benavides, during
Yes.
that, what you just described as they were engaged in that activity, do the speed limits have any relevance?
It is undisputed that Mr. Rocha was driving at a high speed of rate. All of the officers have testified under oath that they did not at any point trigger a high-speed chase pursuant to the city's vehicular pursuit policy. That pursuit policy says that a vehicular pursuit is triggered when there is an active attempt to apprehend a suspect who is attempting to evade arrest. And all of these officers testified over and over again, that was not the intent of them following the individuals. If they were driving at a high speed of rate, it was simply to keep up with him. They were on the radios, calling into the marked units to go ahead and effectuate the traffic stop. The traffic stop would have taken place and they would have then seen if in fact the burglary had taken place. And if so, then they could conduct an arrest.
I'm sorry, go ahead, Justice Rodriguez.
I was just gonna say that the issue that I have is that you just emphasized that these officers were deposed under oath. And so therefore, we're placed in a position where we have, without even being given the opportunity to judge their demeanor as a trial court judge may be able to do, or a jury may be able to do, we are forced into a position then to say, well, these officers are absolutely credible, and they're and that the reason for the suspects to be speeding was some kind of aberration that they did without any action of the officers. And so we're not even allowed to, if we accept your premise, we're not even allowed to surmise that that those suspects may have been speeding because they were being chased, which belies the officer's testimony. I have real issue with that because that's not our position. That's not our job. And so if you're asking us to decide credibility, then I think your argument fails.
I appreciate that, Your Honor. And if I may respond, I would say that there are two issues that would be responsive to your concern. The first is that it's not so much the credibility of the officers, but rather the fact that no evidence exists to the contrary. All of the officers.
Wait. Let me stop you there. Okay. So I understand that you're telling me that there's no direct evidence, that there's no witness that's going to be that was standing on the sidewalk to be able to say, I saw these unmarked police cars or officers in these unmarked cars chasing the suspect. But I mean, it's just like a circumstantial case in a criminal case. I mean, the circumstances are, it gives rise to the idea or the suspicion or credence to the allegation that they may have been doing so. And so therefore, just because there isn't any direct evidence, that doesn't mean there isn't any evidence, right?
Which is,
right?
Of course, yes, Your Honor.
So that to me begs the question of whether or not there is a fact question as to whether or not the accident was caused, and then goes to the issue of the negligence of the police officers, if any.
So if I may respond to that, I would say, first of all, we have to look at the video testimony of the suspect, of Mr. Rocho, where he himself says, I had no idea that there were police officers chasing me.
You're going back to me now looking at the demeanor and the credibility of the witnesses. So that's,
and if we set all of that aside, Your Honor, if we set all of that aside and we go to my second issue, which is addressed in our briefs as well. Even if this court completely disagrees with the city of El Paso and says there is a fact issue, or even more than that, we believe that there was a high-speed chase. There is still not sufficient proximate cause under the law to show that the actions of the police officers, that the use of the vehicles actually caused the injury. So under the waiver of sovereign immunity for use of a motor-driven vehicle, there are two requirements. The Texas Tort Claims Act demands that the plaintiff establish operation or use of a vehicle, and also that they establish a causal connection between the governmental employee's actions and the plaintiff's injuries. So it is not enough for them to say the city of El Paso acted negligently, they engaged in a high-speed chase. They must also show that the injuries complained of actually arise from the operation or use of the motor-driven vehicle. So if we look at what the Texas Supreme Court has said about this, Dallas Area Rapid Transit versus Whitley, it's 104 Southwest 3rd, 540. This is a 2003 case. The Texas Supreme Court says that to arise from the operation or use of property, there must be a nexus between the injury and the operation or use of motor-driven equipment. The plaintiff must show more than mere involvement of property and must show that the use of the motor vehicle actually caused the injury. Now, remember, in this case, none of the police vehicles touched any of the vehicles involved in the accident that resulted in the death. So there are two separate accidents. There is an accident between Mr. Rocho and Ms. Cangulosi's car. And then there is an accident between the City of El Paso vehicle and a separate unit that has nothing to do with the injuries that come up in this lawsuit. So there's case law that we need to look at here. And the first case I would highlight to this court is the City of Dallas versus Hillis, 308 Southwest 3rd, 526. This is out of the Texas Court of Appeals in Dallas. It's a 2010 case. In this particular case, you have a motorcyclist.
I'm familiar with that case.
Okay, so in this particular case, you have a motorcyclist who's speeding, runs a stop sign.
I know the facts of that case.
And in that case, the court said that there was no causal nexus between the use or operation of the city's patrol car and that the use of the patrol car at best furnished a condition that made the accident possible.
Right. And that's not binding on us.
I understand, Your Honor.
Okay.
And there is also a Texas Supreme Court case. This is Lelau, that's Leaux versus Hampshire Fanet ISD, 835 Southwest 2nd, 49. And this is a 1992 case. The Texas Supreme Court case says the phrase arises from requires a nexus between the injury negligently caused by a governmental employee and the operation or use of a motor-driven vehicle or piece of equipment. And I quote, while the statute does not specify whose operation or use is necessary, whether it's the employees, the person who suffers injury, or some third party, we think the more plausible reading is that the required operation or use is that of the employee. That same case is used by other courts of appeals. Again, non-binding, but the Ramos versus City of San Antonio, this is a 1998 case, they apply the Lelau reasoning to say that where a police officer observes a speeding vehicle driving at a high rate of speed, follows the vehicle to find out why he or she is speeding, and then that vehicle crashes into the plaintiff's vehicle, there was no waiver of the city's immunity because the city did not operate the vehicle that struck the plaintiff.
Counsel,
So
do
yes.
do you have any comment on the San Antonio Court of Appeals opinion in Maspero versus City of San Antonio? I think that's 2019, and that obviously kind of takes a different position than the earlier San Antonio case that you just cited.
Your Honor, I think that the overlapping conclusion that the courts have reached is that there needs to be a nexus between the governmental action and the injury. At the end of the day, these are all different scenarios with different facts, but there is absolutely no doubt that there was no contact between any of the marked or unmarked vehicles and Ms. Cangulosi's vehicle or Mr. Rocha's vehicle.
I mean, it kind of seemed to me like you're arguing for a bright line rule that if the police officer doesn't nudge the car, they don't use the tire spikes, that there's no contact, then that kind of defines that there's no nexus. I mean, am I reading your position correctly?
The way I read the case law, Your Honor, is that in order for it to arise from the governmental entity's use of a vehicle, there must be a clear nexus. there's obviously not going to be a black and white response as to, yes, this is a clear nexus and this is not, because we're talking about very factually different scenarios. But in this particular, yes.
So what's the cause of this accident? Isn't the cause of this accident is Rocio going 60 miles an hour and he crests the hill right there before Schuster, and it's kind of a blind, I mean, you can't see the light until you're right up on top of the hill. So, I mean, the causative factor here is speed. And so then isn't the question, why was it going that fast?
The failure to control that speed in that short period of time. You're right, Judge, sorry.
And Your Honor, you might be right that speed was the contributing factor. We don't know whether he had been going at the speed limit and ran into Ms. Cangelosi's vehicle, whether it would have made a difference. Ms. Cangelosi was at a full stop. He rear-ended her. We may be in the exact same scenario had he not been speeding. I would argue that the contributing factor, and in fact, the proximate cause, was Rocha's actions. Whether it was that he was speeding or not, it was the fact that he ran into Ms. Cangelosi's vehicle.
Ms. Benavides, what role does the departmental pursuit policy play in how we're supposed to be looking at the evidence?
So the departmental pursuit policy is not triggered in this case because everybody that was involved in this case on the city's end, the El Paso Police Department, the undercover police officers, they all have testified that they did not trigger a police pursuit. So again, a police pursuit would be triggered when there's an active attempt to apprehend a suspect who's evading. Everybody who testified in this case has testified that it was not a police pursuit. And so therefore, I would argue that the policy really does not really affect how we look at this case, because it is the police department's position that it was not triggered.
And that one's got me a little confused because, I mean, you kept referring to this as a traffic stop. And when I hear the word traffic stop, I'm thinking, okay, you're going to pull him over and ask him for his license and his insurance and maybe ask him a few questions. And then if there's nothing suspicious, you let him go about his way. But Officer Villalobos already, I mean, he testified, or I guess there's a statement where he says, I witnessed a house burglary. I mean, they weren't going to let this young man go away after they stopped the vehicle. They were going to arrest him, right?
They were going to investigate to ensure that the burglary had taken place. And then if it had, then they would have arrested. Yes, you're correct. So if we look at the vehicular pursuit policy, it's very clear that it is a last resort thing that takes place. So the officers testified that when they are engaged in undercover activities, such as they were on March 4th, they are there to identify a suspect, call it in, follow the suspect until the marked unit arrives, and then they walk away. And it's up to that marked unit to pull the driver over, conduct an investigation, and then if necessary, perform an arrest. So I do understand where the court is coming from, saying that there seemed to have already been enough evidence of a burglary. However, that is simply not the way that they would process this type of arrest. They would still have to pull over the suspect, investigate, and then if necessary, conduct an arrest.
So when you described right now that the pursuit policies require the unmarked vehicles to pull aside, it seems as if in this case that didn't happen. The vehicle with the sirens and the lights on was already on scene and engaged, yet the undercover vehicles continued to travel at a high rate of speed.
So it's not the vehicular pursuit policy that says that the unmarked vehicles must pull aside. What I'm saying is that when there is an undercover stint, the role of the unmarked vehicles is simply to follow until no longer necessary. The individual who from the police department who had been called in over the radio is Officer Humberto Herrera. He testifies that it was very clear a burglary needed to be investigated, not that a chase was in pursuit. So what was being called in to the marked vehicles was a potential burglary. They were following the suspect. They were giving the direction of the suspect. Because he was moving at a high rate of speed, they stayed on him to ensure that they wouldn't lose him. But the purpose was not for the unmarked cars to apprehend him. It was not for them to direct him to a certain area and ensure that he could no longer continue driving. It was simply to continue in contact with those individuals who were going to come to the site in marked units to perform that investigation.
Given the standard of review, are there any inferences that we are required to provide in our review at this point? And because we are required to look at the evidence in favor of the non-movement, are there any inferences here that would suggest that the officers had influence on the behavior of Mr. Rocha's driving?
There are none, Your Honor. As I said before, and I understand the concerns of the court, but all of the testimony we have, including the testimony of the suspect driver, everybody is in agreement that there was no pursuit. In reality, the only individual who can say whether or not he was aware that he was being followed is Mr. Rocha. Whether we choose to believe him or not is up to the court, the trial court, obviously. But Mr. Rocha has said, and he told the police officers, he had no idea he was being followed. He talks about a red Jeep. He talks about how the other young man that was with him was worried that the people in the red Jeep had witnessed the burglary, that they might call the police. Mr. Rocha was concerned for himself because he was under some criminal issues himself. And so he was afraid that he was going to get pulled over. But at no point did he see police officers. Was he aware that there were police officers following him? He says that he was speeding because he wanted to get away from the scene of the crime as quickly as possible.
Okay. Thank you, counsel.
So yes.
If there's no more questions, we'll hear from Ms. Coyle.
Good morning. May it please the court, counsel for the city. I'd like to just start right in with just addressing what I see as the city's sort of three core arguments. I was going to remind the court of the standard of review, but the court's well aware of it. At this stage, because the city's plea to the jurisdiction is really a challenge to the existence of jurisdictional facts, our mode of proceeding is really just mirrors the summary judgment standard. And so the plaintiffs have provided Appellees, the Cangialosi family, sufficient evidence to raise fact issues to defeat the city's plea to the jurisdiction on both negligence and causation. So the city first argues that there's no disputed fact that the officers were negligent. Well, as the court had already raised in the earlier argument, speed is absolutely a core issue. The city said there was no disputed fact as to the speed that the suspects were traveling at, but there's no disputed fact that Officer Villalobos, the lead officer in the unmarked unit right behind Mr. Roacho, was traveling at a minimum of 60 miles per hour. The marked unit was traveling undisputed at 72 miles per hour on Stanton, a quasi-residential on one side, light commercial on the other, and the speed limit, posted speed limit, is 30 miles per hour. So Officer Villalobos was disciplined. The internal affairs found that there was a violation of the safety practices and suspended him 8 hours for his excessive speed.
So is the traffic accident report in the record? I mean, I do recall the the expert doing kind of the skid mark analysis, but is the actual traffic accident report in the record that assigns a cause for the collision?
You know, I know there are several pieces of the police report in the record. I don't know if exactly what you're referring to as the accident report is in there. The speed is absolutely in there. That's at CR 122. And I will double check that. Where as part of the analysis of the accident, they did determine the speed. That it's actually a report that's several pages long, but it's CR 122 that indicates the actual speed and the speed limit, the speed that Officer Villalobos was traveling at. So speed, that's negligence. I mean, that raises a disputed fact question that the city's officers were negligent and engaged in negligent conduct at the time the accident occurred. Now, Justice Palafox, you raised the issue of, well, what's the relevance of the vehicle pursuit policy? That is just additional evidence that the officers were acting in a negligent fashion in the manner in which they were speeding down Stanton to pursue Roacho after they had just observed him committing a burglary, knowing that the vehicle was involved in a burglary the day before. The vehicle pursuit policy defines vehicle pursuit, and very simple: an active attempt by one or more officers to apprehend a suspect operating a motor vehicle who is attempting to evade arrest. And the Cangialosi family has provided lots of evidence to show that the officers were in fact engaged in a vehicle pursuit. Now, the city is trying to argue all these different facts to show that they in fact were violating the vehicle pursuit policy, so they couldn't have been, so the vehicle pursuit policy couldn't have been implicated. Well, that's somewhat circular. It's very simple. They were involved in an active attempt. So there was more than one or more. It was Officer Villalobos, and in total 7 units involved in pursuing Roacho, the suspects in the burglary. And the officers themselves stated, Officer Villalobos stated, Officer Herrera stated in sworn testimony, their goal was to stop Roacho. That is an apprehension. The policy itself doesn't say what does it mean to apprehend a suspect, but clearly stopping a vehicle, and whether it's an investigative stop or they're planning on stopping him because they already know that he committed a burglary, there's nothing different about the conduct itself. So while the city is trying to argue that, well, they were only intending to investigate, and I would argue, yes, Justice Rodriguez, that requires a credibility determination, which I think the record would raise a fact issue that they were really not investigating. They were trying to apprehend him for committing a burglary. But the point is that their actions, their conduct, which is what the core of plaintiff's claim is about, their negligent conduct, was in fact happening while they were trying to stop the vehicle, which is an apprehension. And I think the evidence is overwhelming that Roacho was trying to evade arrest. Even if we take the police interview and look at that, he said he was panicked. He had only been on probation 10 days, a 5-year probationary sentence. He had only been on probation 10 days for another burglary. And he was clearly concerned about being apprehended. So it's just another piece of evidence to show that the city's officers were negligent. They overwhelmingly violated the vehicle pursuit policy. Unmarked units are not supposed to be involved at all in any vehicle pursuit. The pursuit needs to be conducted at a safe speed. There should only be a primary and a secondary unit involved. There were 7 in this case, and there are other violations. Even though if we take Officer Villalobos's take on this and the city's argument today and say, well, no, they were just conducting surveillance, which is their position, I suppose, that they're just conducting surveillance at the time that Officer Villalobos is going over 60 miles per hour on Stanton when the speed limit's 30, with 6 of his fellow officers coordinating their efforts with him to stop Roacho. Even if that was surveillance, they violated the surveillance policy. And we've provided that in the record. The surveillance policy requires the investigators to obey all traffic laws. Clearly they did not. They were speeding. They shall not continue a surveillance opportunity if it poses an undue risk to innocent members of the community. Well, this case dramatically illustrates the risk to the community when officers are in violation of their own policies in pursuit of a vehicle. So getting to the third argument that the city raises, and the city really raises 2 separate arguments on causation. One is just sort of your general proximate, there's no evidence that the officer's actions proximately caused the injury. The second causation argument that the city raises is very different. It assumes Roacho was aware of the officers following him, yet the city argues that there's no nexus between the operation or use of the vehicle and the injuries suffered by the Cangialosi family and the death of Annette Martinez. Let me just quickly deal with that second operation or use argument. That argument was raised for the first time in the reply brief. That argument was not raised in the initial brief. The city cites 8 cases in the reply brief to support that argument regarding operation and use and an improper nexus. None of those 8 cases were cited in the initial brief. So our position, and we think the authority of the court supports that the city has waived that argument. In a similar case,
counsel, just not to get too far down this road, but a plea to the jurisdiction, we're talking, I guess it questions the trial court's jurisdiction, which I did not think was a waivable argument. Isn't that, if the trial court doesn't have jurisdiction because the Tort Claims Act has not been met, does it matter when that issue is raised?
Well, I agree, Your Honor, that jurisdiction is not waivable, but the specific argument that the city is raising, since it was not, that it's a separate causation argument, they still have preserved their other 2 arguments regarding negligence and general causation, that they have failed to properly preserve that separate jurisdictional argument. Now, I don't know, maybe they could raise it again and there could be a separate round. We'll be back here again. I'm not sure procedurally, but the Cangialosi family has not had an opportunity to respond to those arguments. And I'm prepared to respond right now on those arguments, and we can talk about that in a minute, but I just wanted to raise the waiver issue. And there's some authority for that. Bankhead versus Maddox, the Court of Appeals out of Tyler, Texas, 135 Southwest 3rd, 162. Now that case, Justice Ellie, as you pointed out, did not raise jurisdiction. It's a different issue. It was regarding attorney's fees. But in that case, the plaintiff was successful at trial, was not awarded attorney's fees, argued on appeal. She should have gotten attorney's fees under the Civil Practice and Remedies Code. Then in her reply brief, raised a separate argument as to why she should be awarded attorney's fees under a separate statute, and the court said you waived that argument. The 8th Court of Appeals cited that decision favorably in Taylor v. Meador, M-E-A-D-O-R. Justice Wellington Chu authored that decision, and that's 326 Southwest 3rd, 682, and that's a 2010 decision. So okay. Let me first.
Well, I was going to say I appreciate that argument, but I do want to hear what your position is on this Hillis case from the Dallas Court of Appeals.
On Hillis?
Yes.
Okay. All right. So Hillis, let me talk a little bit about that case. Hillis, and I just grabbed it. One sec. I have to say, I really miss not having a podium. So in Hillis, the court, there was a motorcycle that was going, well, we know the officer was going at least 105 miles per hour when he was pursuing a motorcyclist. The motorcyclist then takes an exit ramp where I believe the speed limit was 45 miles per hour, and then goes off the ramp and he ends up killing himself. So the first couple things that I think are very important regarding Hillis that's distinguishable is that the court raised the issue of the break of the chain of causation because the injured party, Hillis, his own conduct caused his death. And so that's one important distinguishing characteristic between our facts. Joanna Congelosi was simply sitting at a red light, waiting for the light to turn green with her infant daughter and her mother. She was not engaged in any kind of negligent conduct to cause her own injuries. The other issue about Hillis is that the court said that even though the officer was going 105 miles per hour, it took the officer 10 seconds to get to the area where the motorcyclist lost control. And so in this inquiry regarding the nexus between the operation or use of the vehicle and the injuries, the court really drills down into temporal factors, geographic considerations, and that link, that attenuation between the conduct of the officers and the injuries. And so the court in that case said it was just simply too attenuated, time and geographically, for us to find that the use and operation caused the accident. In our case, we have the opposite. We know that Officer Villalobos was right behind the suspects. We know that the suspects were trying to evade arrest. We know that Officer Herrera had his lights and sirens on, going 72 miles per hour. He had passed the unmarked units. At some point, he saw a white vehicle. He didn't confirm whether that was the Acura or not, but he had a visual on it. And so we have a strong link between temporally, geographically, between the negligent conduct, which is the excessive speed of the officers, and the suspect increasing his speed as a result to flee and evade arrest. And it was that that link, that tighter link between the officer's conduct, Roacho's conduct, and then hitting the Congelosi vehicle. The other thing a number of those cases cite or deal with are really, the city had identified several others, and if the court wants, we can talk more about them. But for each one, there's always, they're very different. So for example, Lalou that the city cited, the high school student in that case had entered a school bus that wasn't, the driver wasn't on the bus wasn't on, it wasn't, running, and she hit her head on an emergency door. Okay, so no nexus there between operation and use and injury. Whitley, the Dallas area rapid transit case, the person was forced off the bus and then was assaulted. Again, no attenuation, very different in our case. We already talked about Hillis, where again, there was a distance, temporal attenuation. Teague versus City of Dallas, another case cited by the city. In that case, the officers said they were not in a pursuit, and it didn't seem like it was a disputed fact issue. More importantly, in that case, the city, the injured party never alleged that the officers were engaged in any negligent conduct. And also, the driver had made a sharp turn and a change in direction, and we don't have that with Roacho. He's just traveling at a high rate of speed, with the officers, with Officer Villalobos directly behind him. The other case cited by the city, Ramos v. City of San Antonio, the officers actually exited their car, I believe in this case, let me see. Oh, I'm sorry, that's incorrect. The other case with Ramos v. City of San Antonio that the city cited is that the officers were not attempting to stop this at all. In our case, we have the officers admitting in sworn testimony their goal and their reason for traveling down Stanton was in fact to stop the vehicle. That fact is undisputed in our case. So we believe the facts raise a disputed question as to whether there's a nexus. And again, drawing the inferences in favor of the non-movement, the Cangialosi family, the court should deny the city's plea to the jurisdiction on that basis. Very briefly on the issue of causation regarding Roacho's awareness, there's just sort of three quick comments I'd like to make regarding Roacho's own statement that the city is relying on exclusively. One, it's not competent summary judgment evidence. It was not a sworn testimony. Two, it's not in Roacho's interest to admit that he was trying to get away. Murder in Texas is a person commits murder is if they commit a felony and in immediate flight from that felony commit an act that's dangerous to life and in fact causes death. So Roacho, as he's sitting in that police interview without counsel, it's clearly not in his interest to say, oh yeah, I knew the officers were behind me and I was trying to get away after I just burglarized a house. The statement
seemed pretty surprised. He seemed pretty surprised though at the end of the interview when they arrested him for murder, right?
That is true. That is true, Justice. Yes, he did.
And the fact that the statement was unsworn, was there an objection that was ruled on by the trial court?
That's correct, Your Honor, and we lost that issue.
Okay.
Yes, we raised it, and the trial court allowed that evidence to be considered on the plea. But it really is a credibility determination at the end of the day with Mr. Roacho, because the statement's also internally inconsistent. He says over and over again, I'm panicked, I did wrong. At one point he says, this guy had just cut in too close to my car, I panicked. So that gives an overall impression that he is trying to get away and that he is fleeing. But in any event, the Appellee's, the Cangialosi family has provided really sort of 5 big categories or pieces of evidence that really raise this question of Roacho's knowledge and really creates a disputed fact issue on Roacho's awareness. And let me just quickly go through that evidence. Number 1, Officer Villalobos indicated on the radio just minutes before the burglary that the suspects spotted him. Verbatim, he says, they started weaving in and out once they spotted me. So just minutes before they committed the burglary, as they're conducting or casing the neighborhood, they had started weaving in and out when they saw Officer Villalobos's unmarked unit. Number 2, Officer Pacheco.
Can you give me the record site for that, please? I'm sorry, can you give me the record site for that statement?
That's 212.
Thank you.
So, and Justice Alley, I should point out that what happened is we've actually provided the audio to the court. It's a 13-minute audio, only a small piece of the audio. There was a transcript, so the transcript's in there, but this piece of it is not on the transcript. So you do have to listen to the audio in the record to hear Officer Villalobos. I did identify the time. I believe he makes this comment at 1:33 p.m. So if you listen to the audio and to save you the 13 minutes, if you go to 1:33, you should be able to hear him make that comment. Then Officer Pacheco says, again, these officers are, it's a stakeout. I mean, they are all in the Kern neighborhood. They are all positioned very close to where the burglary occurred. Most of them have a visual, and you can see that from the record. Officer Pacheco is also in an unmarked unit, and he states And this is in the transcript. This is at CR 214. On the radio, he said, Villalobos is right behind them right now. They are picking it up. Again, we've got a contemporaneous view by the officer watching the burglary, watching the burglars, watching Officer Villalobos fall in right behind them as they're picking it up. Officer Villalobos says, we're, referring to him and the suspects, going south on Stanton, they're picking it up. Again, we've got evidence showing that as the officers are engaging in the pursuit, the suspects are increasing speed. The obvious inference is they're trying to get away from the officers. Officer Moreno states that he would have anticipated that they would have slowed down when they got away from the home on Stanton, but instead they picked up speed. Again, an observation that would suggest that even though they're at a safe distance from where they had just committed the burglary, they're picking up speed to get away from the officers. Fourth piece of evidence that's very important, Officer Villalobos was traveling on Stanton in pursuit at a minimum of 60 miles per hour in a conspicuous fashion. He said in his own statement, he was in the inside lane and the outside lane. He also said the suspect's vehicle was driving in two lanes, switching, using the inside lane and then the outside lane. That behavior, again, would suggest that the suspects are trying to get away and that Officer Villalobos is pursuing. It would also draw attention to Officer Villalobos's vehicle. Officer Pacheco also referred to them as weaving in and out of Stanton. Finally, the other piece of evidence that would suggest that Roacho was aware of being followed is Officer Herrera's conduct. He testified unambiguously. He's the takedown unit. His goal is to stop them. As soon as he turns left onto Stanton, he activates his lights, his sirens, and his speed, again, undisputed, is 72 miles per hour on Stanton. That fact also raises an inference that the suspects would have been aware of this happening behind them and were traveling fast to evade apprehension. And so, also Herrera, again, he says, I'm trying to catch up to the white Acura. I'm running code 3 on Stanton. Clearly in a very visible, active way, trying to apprehend Roacho and his accomplice. And so we believe we've provided more than enough evidence to defeat the city's plea to the jurisdiction. There are strong disputed fact issues on the officer's negligence, strong disputed fact issues on both arguments regarding causation, the argument that Roacho was in fact aware and was of the officer's presence in pursuit, and strong evidence showing a disputed fact issue on the nexus between the use of the vehicle and the injuries to the Cangialosi family. And for this reason, we'd ask that you affirm the trial court decision and deny the city's plea.
Thank you, counsel. Ms. Benavides?
Yes, your honors. I will be brief. With regard to the allegation that Roacho was aware of the officers, specifically of Officer Villalobos, being in the area prior to committing the burglary. If we are talking about whether or not we believe Roacho, it wouldn't make any sense for him to go and commit a burglary after he has spotted the police in the area. This is something that was discussed in the trial court level. This is an issue that the court took with that argument that plaintiffs had at the time. It's an issue that the city has taken with that argument. The fact that appellees are saying, don't believe Roacho when he says that he didn't know the police was following him, but do believe that he spotted them prior to committing the burglary and still committed the burglary, doesn't really make any sense. In addition to that, the fact that Roacho would have been afraid to be pulled over near the site of the crime because he was on probation does not mean or does not provide any evidence showing that he was aware he was being followed. So the fact that he may be fleeing the scene of the crime because he's afraid to be pulled over does not mean that he is fleeing the scene of the crime because he is aware that he is being followed. And I think that's an important distinction to make. So we've talked a lot about whether there's a nexus, whether there's proximate cause, and there was a conversation that Ms. Coyle brought up about whether the city had waived certain arguments. And Your Honor is correct. A sovereign immunity argument with regard to the court's jurisdiction to hear a case is not something that the city can waive. It's something that the city can bring up at any point. But in addition to that, if you look even as far as the first plea to the jurisdiction that was filed at the trial court level, the city has always made a proximate cause and nexus argument. The reason the city has always made it, and the reason it is not a novel argument, is that the Texas Tort Claims Act gives us very specific areas where sovereign immunity is waived. One of those being, as we discussed, the use or operation of a motor-driven vehicle. That specific waiver of immunity requires proximate cause and a nexus. So this is an argument that has developed as we've argued it. And as Ms. Coyle correctly stated, we've added new cases to build up that argument, beef it up, but it is absolutely not a new argument that the city is making. We have always argued that there is no proximate cause and that there is no nexus. With regard to Rocha's statement, and this was brought up earlier, Appellees had moved to strike the statement at the time that the trial court heard the plea to the jurisdiction. The trial court ruled on that. The trial court ruled in the favor of the city, allowed Rocha's statement in, and it was considered in the sense that Rocha was making a statement about his state of mind when this happened. The fact that he was terrified that he was going to get pulled over, again, does not mean that he was aware of the fact that he was being followed. The fact that he was driving erratically does not mean that he was aware he was being followed. So the reason we need to look at all of these circumstances is, again, the fact that sovereign immunity cannot be waived for the use of a motor-driven vehicle unless you have that proximate cause or nexus. And that's something that we know, it's in the law. There has to be evidence that that exists. And that is not something that is proper for a jury. That's something for a court to determine, because it's something that goes to whether or not the court should hear this case.
So Ms. Benavides, how do you articulate the application of the standard of review? Does the city take the position that the evidence proves as a matter of law that there is no nexus?
The city's position, Your Honor, is that appellees have failed to plead sufficient facts to show that there is a nexus. And under the laws that rule a plea to the jurisdiction, you look at the pleadings on their face, whether or not they have pled sufficient facts to show that there is a waiver of sovereign immunity, and they have not. So it's a factual issue.
But I thought once the parties start putting evidence into the record, we kind of move away from the pleadings and look at your evidence and their evidence to see whether there is a fact issue. That is, whether there is a scintilla of evidence that would raise a genuine issue of material fact on any of these key jurisdictional issues.
You are correct, Your Honor, that the court can look to the facts when necessary in determining whether there is jurisdiction in a plea to the jurisdiction type of argument. However, in this particular case, we have gone through the full extent of discovery, depositions. There's really not much more for us to uncover in this case. And what we have in front of us is what you have seen in the briefs. That is all the evidence and all the testimony we're going to have. It is still our position that based on all of this testimony and all of this evidence, the appellees have still failed to sufficiently plead a waiver of immunity. Again, because they aren't able to reach a proximate cause or a nexus of the use of the motor-driven vehicle that the police department used that day and the injuries that are complained of. So the proximate cause of the collision that resulted in Ms. Martinez's death was Rocha's conduct in driving that 1997 Acura. It was independent of any action that the police department did or did not take that day. The evidence in the record supports the city's position that the officers did not engage in a pursuit pursuant to the vehicle pursuant policy, and that the suspects were not aware of the police presence. In fact, the only individual able to testify, as I've said before, whether or not the suspects were aware of the police presence is Aaron Rocha. And he has testified that he was entirely unaware of any police presence as he fled the scene of the crime. No other person, not even the officers who were present on that day, are able to say in such certain terms whether the driver was aware of their presence. The city's use or operation of a motor-driven vehicle did not affect or induce Rocha's criminal actions on the day in question because he was not aware of the city's presence. Had he been aware of the city's presence, he probably would not have committed the burglary. Even if we assume that Rocha was aware of the police presence and that he was attempting to flee for that same reason, appellees cannot show and have not shown that there's a nexus between the use or operation of the city vehicle and appellee's injuries. Appellee contends that the evidence in the record creates a fact issue, whether the officers acted negligently and whether their actions proximately caused the injuries to appellees. The vehicles driven by the city of El Paso police officers did not make physical contact with either the vehicle driven by Rocha or the vehicle driven by Joanna Cangelosi. That fact is undisputed. Pursuant to Section 101-021 of the Texas Tort Claims Act, the city does not waive its governmental immunity for allegations involving the operation or use of a motor-driven vehicle unless that operation or use causes the injuries alleged. The evidence in Appellant's brief and its application to well-established Texas case law that we've discussed today demonstrates that the police department's actions were physically and temporarily separate from Rocha's actions. As such, the city would argue, Your Honors, that there was no operation or use of property that actually caused the accidents complained of in this lawsuit.
Thank you to both counsel for your excellent argument. You are part of a small piece of history in that this is the first Zoom argument of the El Paso Court of Appeals, and I think in our 110-year history. So you can always carry that with you. And I do appreciate your excellent argument, and we will take the case submitted on your argument and your briefs, and you will hear from us. So thank you so much.
Thank you very much.
Thank you.
Thank you.
So I'm going to exit people from the argument here.
We can all.
There you go.
Okay, let's see, I've got to stop the YouTube thing too, so wait.